beyond the two primary litigants. The effects no doubt will reach the 20-plus potential MMTCs that the trial court allowed to intervene as additional plaintiffs, and the effects will reach the legislature in terms of the scope of its power to direct the Department of Health on how to control the markets for the manufacture and distribution of a Schedule I federally illicit substance. The House has a direct and immediate interest if Florigrown wins. The House, along with the Senate, loses. The trial court abused its discretion then when it failed, as a legal matter, to recognize the legislative interest in the outcome and denied the House the opportunity to defend the legislative prerogative in this highly consequential and unique constitutional litigation.
Counsel, if I could ask you a question. In this case, as I understand it, the intervention didn't occur until almost a year into the case. The trial judge had already opined on the constitutionality of the legislation. And the House, put that aside for a moment. Surely the House has an interest in its own legislation. I get that. That's pretty obvious. But under the circumstances, was it an abuse of discretion at this stage of the litigation? That's question one. And along with that, it looked to me as if perhaps around the same time the governor, he wasn't elected at the time, but I think it was just late October, had said that his healthcare platform was to support the medical marijuana. Did that have anything to do with those two questions?
If I may take them
Sure.
in order.
Any way you want.
So, Your Honor's first question is regarding the timing of the House's well, I guess they're related, but specifically a year in the litigation, is that an abuse of discretion to deny the House's motion? The answer to that question is no. Yes, it is an abuse of discretion. The decision of the trial court should be taken in context. First of all, yes, it was a year into litigation. I will note first that Glisson case of this court, the interveners there, the court reversed a denial of motion to intervene, and that was 23 months into the litigation and 6 months before trial. And still this court reversed an order and found it was an abuse of discretion. And the reason for the abuse of discretion is because the trial court erred as a legal matter in identifying or not identifying the cognizable legal interest of those parties. The abuse of discretion here occurs on the front end because the trial court never rejected the idea that the House had a cognizable legal interest in the first place. Why? Because the court had already, according to the trial court, had already determined the constitutionality of the statute or the unconstitutionality of the statute. So what left was there for the House to do?
And that was for injunctive purposes at that point.
Correct. Right? It was for injunctive purposes. It wasn't a final determination, and I was going to that point. That's an important distinction as well. The trial court made a preliminary determination, the likelihood of success. And it's just not the test for intervention is, well, I've already made a preliminary determination as a matter of law, so there's nothing more that you can contribute. The test here, as with any other potential intervener, is there a legally cognizable interest? And then once the court makes that determination, then go to the second question, which I think is where your first question is there some other reason why it's going to interfere with the case? It's going to add new issues to it. That's the exercise of discretion that would occur, and and that didn't happen. And I want to note, still going to your first question, right after the trial court denied the House's motion to intervene, actually the same day, the trial court let, I forget the number at that time, but ultimately within a few weeks allowed over 20 additional plaintiffs to file their own complaints and that type of thing. So it would be an abuse of discretion on the discretion side if the trial court was saying, and it never got there, but the trial court was saying, I'm not going to let the House intervene because we're about to go to trial and I don't want to mess up the record and disrupt the proceedings. That wasn't the basis.
It seems that at least the argument of your opponent is primarily based on these cases that have said the legislature is not the party to be sued. But isn't there a big difference here where at least one half of the legislature comes in and says, we want to be involved. This is a monumental change in law. It will affect our policymaking powers. And then cases where a party just sort of willy-nilly sues the legislature, when obviously the proper party to be a defendant may be solely the enforcing body. Tell us how this is different than those cases.
Yes, Your Honor, and then I promise I'll get back to Judge Makar's second question.
You can answer his first if you like.
Keep your train of thought. Go
Okay.
ahead. Go ahead.
And the court is referring to, Judge Thomas is referring to Atwater and other cases that Florigrown has relied on. There's an important distinction, and this is another area where the trial court got it wrong. The trial court actually did rely heavily on Atwater, as does Florigrown. Atwater, as I think Judge Thomas, you were noting, Atwater was a standing decision, not an intervention decision. Atwater didn't have anything to do with intervention, which is a different standard and a different inquiry. In Atwater, the problem that the plaintiff had was they didn't sue anyone that had the authority to enforce the challenge law. And as it turns out, it was the Department of Community Affairs. I think, Judge Thomas, you were on that panel at the time. And the note, Atwater sets a baseline. Before the case can go forward for purposes of jurisdiction, you have to have one party on the plaintiff's side that suffered an injury and at least one defendant on the defendant's side that has the ability to give the relief that the plaintiff is seeking. The problem in Atwater is that there was no one that could give that relief, and it ended up would be an advisory opinion. It was a jurisdictional problem, and that's why Atwater came out the way it did. Atwater does not stand for the proposition that the only parties that can intervene are the parties that would satisfy either side of the V for purposes of controversy. If Atwater stood for any other proposition, then there's a whole host of other cases that don't make any sense, including Glisson, which we maintain is controlling here, and it's certainly highly persuasive. In Glisson, you have environmental groups that asked to intervene in a land use management amendment to the local ordinance, and it was the county that was sued, and you had a number of property owners that were the plaintiffs. And these environmental groups, on behalf of a few of their members that happened to live in the area that was going to be affected by the amendments, they were ultimately, this court ordered that they be allowed to intervene because they had an interest in it, potential interest, because the ordinance, because they had an interest in having more wildlife in the area and having more bucolic areas and more wetlands and less development. And the reason I bring that up and bring it up extensively here is, if you're talking about standing, if Atwater stands for the proposition that as a defendant you can't intervene unless you're the enforcing party or the party that can grant relief, the environmental groups certainly would not have been able to grant the relief that the plaintiffs were seeking in Glisson. So to answer the court's question, Atwater is a standing decision, and standing is not the test and not the question when it comes to intervention. In intervention, it's liberally granted, and the question is there a legally cognizable interest? And here the answer is yes with respect to the House. Now, Judge Makar, you had asked about the governor, and was there anything that had to do with the governor's announcement about...
What I'm getting at is sometimes one branch of government decides to go one direction, another branch decides to go the other. When the Obama administration decided not to defend the Defense of Marriage Act, the House intervened and brought in Paul Clement, and the case went on its way. So that's what I'm getting at here. Is that perhaps informing us about what happened here? In other words, I mean, some of that, shouldn't that be a consideration, that if one branch has a fear that the law might not be defended, they should be able to intervene as a defendant? Sure,
and the reason we brought that up in our briefs, that issue, and we discussed departmentalism in the reply brief, and what that highlights. And it wasn't, I don't want to go so far as to say that, well, we want to intervene because we don't like what the Department of Health is doing and we think we can do a better job. That's not the case. What is the case is it's to highlight that the state doesn't always speak with one voice. And in particular, in a case like this is unusual. This is the first provision out of the Constitution where a statutory agency, a statutorily created agency in the executive branch, is directed to implement policy that's in the Constitution. So you're going to have, there is a natural tension between, and I think, Your Honor, you saw it a little bit in the oral argument a month ago in the temporary injunction hearing. There is a tension, there are competing interests. And we said in the briefs, as a practical matter, if the Department of Health, let's say, were to lose the underlying case, it actually still might gain in terms of power. It certainly comes at the cost of the legislature, because the legislature is going to have a diminution in power.
And wasn't that reflected in the trial judge's order, where he seemed to let the legislature have it, in part because they have no authority either to intrude on or attempt to marginalize the responsibilities of the executive branch. So he's setting up the executive branch in a way that's different, or maybe putting them at odds, so to speak, with the legislatures, with the statute.
That's right, Your Honor. And this is in the realm of public law litigation. We're not talking about two private litigants going out and discussing private rights. This is a broad public policy dispute. Florigrown has a position. The Department of Health is on the defendant's side, defending the law, and it has a position. But in public law litigation, where policy is at stake and the ultimate order is going to have the effect of law in its way, if it is in favor of Florigrown, it's going to have the effect of...
It's going to have a huge effect.
It's going to have...
It's just like the related case. It's going to have a massive effect by invalidating an entire legislative regulatory scheme where the legislature carefully compromised and reached a decision on how many medical marijuana treatment centers. The trial court's order essentially invalidates that scheme. If you're not allowed to intervene, there's no legislative policy decision-making branch being protected, right?
That's correct, Your Honor. And what I also wanted to point out with respect to departmentalism is it can't be said, and the trial court suggested this, that the Department of Health is enough to defend the interest of everybody. And that's, again, not necessarily the case, and it's certainly not the case here.
And the amendment itself grants your branch the power to implement legislation relating to the amendment.
Yes, Your Honor. And that's the interpretation of the amendment is going to have broad implications about the separation of powers, and when you look at when the Florida Supreme Court approved this amendment for the ballot, it was clear it would have implicated single subject issues that had been otherwise. They were very clear, and I suspect the sponsors knew this as well, and that's why the provision's actually in there, I'm assuming, reserving the legislative power, is there was no shift. The amendment does not shift at all any policy-making power to the Department of Health. If you start back and before the legislature typically would have the power to regulate markets and put in restrictions and deal with what a market should look like, including with marijuana. It would presumably, it obviously was illegal before the amendment, and there's an allowance for it now for medical marijuana. But before the amendment, certainly the legislature had the authority to control those markets. Florigrown's position now is with respect to medical marijuana, the distribution, the manufacture and distribution of marijuana for medical purposes, the legislature doesn't have the authority to regulate that market. There will be a time to address the merits of that, but that is a position, and if you go back to the standard for intervention, is there an interest that directly and immediately arises out of the claim in the suit? The answer is firmly yes here. I mean, Florigrown's asserting that the legislature doesn't have the power to do this particular thing.
Could I clarify one thing?
Yes.
You're seeking permissive intervention. I don't believe you're seeking, they're taking the position that you're a necessary defendant.
No, Your Honor.
Okay.
Not taking the position that we're necessary.
Because, I mean, I would assume that if that's the position you're taking, then every time a statute's challenge is being unconstitutional, you're going to be a necessary party.
That's the right question, and yet the court is correct, that we're not asking that a new standard be set or that the current standards or statutes be upended. We're asking only that the typical intervention standard be applied the same to the House and have the House not be treated differently than another interested party, and just have the standard here. And looking in this particular case, it's an unusual case, in an unusual set of circumstances with a possible rearrangement of powers.
What do you say to the argument in the appellee's brief that it's the Attorney General who's designated to defend the statutes in the state, and she's refused to do so, and you're just dissatisfied, the House is just dissatisfied with that, and that your remedy is to amend the statute to allow you to override the Attorney General's decision?
Well, 16.01, the Florida statutes, assigns as one of the duties of the Attorney General and allows the Attorney General the power to appear in court when the state is a party. It's much more mandatory when on the appellate level, and Bondi v. Tucker indicates that it's a discretionary decision. I know Judge Makar and Judge Osterhaus in particular understand there are a variety of decisions or a variety of considerations that go into when an Attorney General is going to intervene at the trial level when a statute is challenged. I don't know what the reasons are for the Attorney General staying out of it, but for the same reason that the House and the Senate shouldn't be subject to veto power of the Department of Health because the Department of Health is defending it, we can't come in and defend it. The same with respect to the Attorney General, and that 16.01, again, is discretionary. It doesn't assign the Attorney General the exclusive authority to appear. And I do want to note one other thing. I know I'm in my rebuttal, but I want to answer the court's question if that's okay. 16.01 references when the state is a party, and I want to be clear that the House is not trying to intervene here to speak on behalf of the state. The House is seeking to intervene in its own right, in its own behalf, to assert the legislative interest, and I think that's another distinction, and the statute does not preclude that, and allowing the House to intervene is not going to upend case law dealing with 16.01 and the Attorney General's discretion to be involved or not be involved in a particular case. For these reasons, Your Honors, we ask that the order denying intervention be reversed and with instructions that the House be allowed to intervene. Thank you.
Good morning, Your Honors. May it please the Court. I'm Catherine Giddings here today on behalf of Florigrown. Your Honors, we keep hearing a lot about separation of powers, and the Supreme Court's already addressed that question. As the House conceded in its brief, in the ballot summary decision when the Supreme Court was evaluating the validity of the marijuana initiative to be placed on the ballot, one of the reasons that it was attacked was that there was this tension between giving the department these powers. And in that opinion, the Supreme Court unanimously said, the proposed amendment does not substantially alter or perform the functions of multiple branches. If the proposed amendment passes, the Department of Health would perform regulatory oversight. The Department of Health would not be empowered under this proposed amendment to make the types of primary policy decisions that are prohibited. And we have not said that the House cannot enact laws. The amendment itself says they can. What we've said is they can enact laws that are unconstitutional, and as this court recognized last week, that is exactly what they did in imposing regulatory...
Well, that case isn't final, right?
Well, Your Honors, it's really interesting that you asked that question, because the House...
I don't think it was a question.
Well, the House submitted a lot of supplemental authority on Thursday, apparently for the proposition that a temporary injunction is not binding on the court or the parties. Well, this court's decision in Silver Rose Entertainment versus Clay County at 646 Southern 2nd 246 says that a temporary injunction can be binding on the parties and the law of the case when there has been a full evidentiary hearing on the merits. The parties have had an evidentiary hearing and have been heard, and the parties ask the court to rule on the merits. And that is
That's not what
exactly
happened
what happened in this case. There were 2 days of evidentiary hearings in this case, and the trial court issued an injunction after having 2 days of evidentiary hearings. And in the primary case, the department asked on pages 15 and 16 of its brief that the court go ahead and reach the issue on the merits.
Well, I remember
And-
an oral argument, both sides were wanting us to get to the
Yes,
merits.
yes, both sides, and this court's Silver Rose decision. So the Glisson case is not applicable here at all because,
Well, what's the harm of allowing the House in? I mean, they just want to defend their law.
well,
it seems like
because
such
the
a-
House is
it-
trying to
pardon me,
interject issues that aren't here.
It seems like such a modest request. We're here to defend our law.
Well, the law is clearly unconstitutional.
Well,
They came in so late.
That's no answer to the question. I mean, let's say it is clearly unconstitutional. They have a right to perhaps come in and say why it's not unconstitutional.
Well, I would disagree respectfully, Your Honor, because they've waited so late to come in. We've already
So is
had the
your-
evidentiary hearing.
Your argument is essentially since they waited till after the injunction was issued, it's too late?
Yes, Your Honor, that's exactly what my argument is. They should have come in way earlier, and it's really interesting because they filed their motion to intervene on the exact same day that the department moved to dismiss the state as a party. And so I don't know if that's a coincidence, but they clearly didn't like the way the department was defending their position. But, Your Honors, I mean, there's nothing left to be done here other than issue summary judgment in our favor.
Well, you say that,
and
But the
retain-
rehearing period is still pending.
Well, yes, Your Honor, the rehearing period still is ongoing, but, Your Honors, I mean, it's our position that the statutes are clearly unconstitutional, and the legislature itself in 381-986, 8E has a severance provision in there, and it only severed the only part that this court declared unconstitutional were these the special classes on who can register as an
But
MMTC.
that is a major decision by not this court, by the way, by the trial court that opens the door to widespread distribution of marijuana in that, correct me if I'm wrong, under the amendment's language, all those functions, which it does end with the word or, not and, I understand that. So everybody who does any of those functions is going to be a medical marijuana treatment center under the trial courts, at least under the trial court's ruling on the injunction. So somebody who grows marijuana alone is a medical marijuana.
No, Your
won't
Honor,
there
no,
be
Your Honor. Let
hundreds-
me make something.
Let me finish.
Let me address
finish.
that point.
Let me finish. Let me
I'm sorry.
finish.
I'm sorry. Go ahead.
Thanks. So won't there be a large number of entities that qualify as medical marijuana treatment centers until the legislature can perhaps meet in special session, enact another law, and completely redo the regulatory scheme?
Your Honors,
Because there are 20-something interveners, right?
there are.
I assume they think they qualify as a medical
Well,
marijuana
the
treatment
reason
center.
that they came in was because the temporary injunction directly and immediately impacted them. It did not, and so there's when you have an injunction that says MMTCs can be registered, then of course you have a direct and immediate interest. But there's nothing preventing the legislature from coming in and enacting laws that are constitutional. But remember, I think something that's very important that goes to your question. Registration does not mean you can touch any marijuana at all. It just means that you have to accept the application to consider whether they can come in. This court's decision said that the department needs to enact regulations, and they can do that. We're not saying the legislature can enact things, but what we're talking about is a medical marijuana amendment to the Florida Constitution that gave the department 6 months to promulgate regulations and 9 months to begin registering medical marijuana treatment centers. And here it is 3 years later, and they're still operating under an unconstitutional scheme. The legislature is attempting to inject new issues into this case long after it's already been over. The time for it to come in was a long time ago. And now that the court has already made the determination on the constitutionality, what is it that they're going to add? They're going to raise all these separation of powers issues that the Supreme Court has unanimously determined is not at issue here?
But the ballot summary cases don't resolve the merits of any underlying constitutional arguments regarding the validity of the amendment. In fact, the Supreme Court declared the death penalty amendment unconstitutional after the voters approved it. So the fact that a ballot summary is approved doesn't mean that the underlying merits of the amendment itself are immune to attack, does it?
Your Honor, if the Supreme Court in this case says that the amendment does not impact the legislature's policymaking functions, and that the policy has already been enacted it's already been determined by the citizens of Florida.
But the trial court's order could violate the separation of powers, and I assume the House may be making that argument if they're allowed to intervene.
Well, Your Honors, where were they before when the trial court was going through this evidentiary hearing and hearing all of these issues? Because under the binding case law, under the Silver Rose case, there doesn't have to be another evidentiary hearing. We've already had 2 days of evidentiary hearing. There was live testimony, there were deposition excerpts, there were numerous exhibits. There's nothing more to be heard. The laws the laws that the legislature enacted were unconstitutional. It can come back to the drawing board. It can quickly meet and fix those, but it shouldn't be coming in now.
Well, this is an unusual case in a lot of ways, and one of the unusual aspects of the case is our decision from last week is not final.
Well, that's true, Your Honor.
It's subject to rehearing. So the decision of the trial court to grant the temporary injunction has not yet been upheld in a final decision of the court. So but the other unusual aspect of this case is that this amendment was a monumental change to the law and allowing the distribution of a drug that is illegal under federal law, that is illegal under Florida law, except to the extent it's authorized by the amendment, and a circuit judge has declared this regulatory scheme invalid. How can the House not be allowed to intervene on the merits of that determination, even assuming the injunction, assuming our decision becomes final? The merits have not been made on the determination.
Well, Your Honors, you have a statutory scheme here in which the legislature set up, in Judge Makar's word, an oligarchy. We called it a cartel.
Oligopoly.
Oligopoly. Okay.
That's a form of government.
Thank you for correcting me. But, the word in Judge Weatherall's opinion is even more complicated. Oligopolistic. But Your Honors, this is a situation in which the legislation is so blatantly unconstitutional that if you read the 381-986, you will see that what the legislation actually did was it granted this competitive, it gave licenses to these people that had already been denied licenses without any additional qualifications, and then for those few extras that it did allow, it allows them to sell the licenses
But it's for
the
this
next
court.
day.
It's for this court to decide if the statute's unconstitutional, not the trial court. This court will decide whether the statute's unconstitutional. So it's not blatantly unconstitutional until we decide whether it is or not, and our decision is subject to further review, obviously, by the Supreme Court. We won't know if this statute is blatantly unconstitutional or completely valid, whether or not that paragraph that refers to all the factors that are part of a medical marijuana treatment center, the trial court's rationale is that, anybody who does any single aspect of that paragraph can be a medical marijuana treatment center. Some may beg to disagree.
We're not saying that there can't be limitations. We have never said that. We said at the oral argument in the other case that we are not saying there can't be limitations. We're saying that there has to be a rational basis for those. And, of course, the blatantly unconstitutional are my words.
You're not making the argument that the statute has no rational basis, are you?
Oh, absolutely. We made the argument that
That the
there was no
limitations
rational
of the
basis
medical
for
marijuana treatment center have no rational basis?
Yes, Your Honor, because it actually, if you get into the merits of the constitutionality, and I know we're not here today on that, but if you get into the merits of the constitutionality, there was no rational basis to give licenses to people who were in a lawsuit with the department, and they were suing because they had not been given a license, and they turned around and just gave them all a license.
Why shouldn't the House be allowed to intervene to question that decision, to defend that legislation?
Well, Your Honors, there was already an evidentiary hearing, a 2-day evidentiary hearing on all of that, and the House did not come in and intervene.
That's on the injunction. The question of whether the statute's unconstitutional is de novo.
Well, that is true, that the but it was on an as-applied basis and a facial basis that the evidentiary hearing was on, because we were able to show that the way in the evidentiary hearing we were able to
According
show,
to the trial court.
according to the trial court, Your
What's the
Honors.
status of the litigation in the trial court now? Has it been
It has been
stayed?
stayed pending the other case.
So
that-
if our panel decides that intervention should have occurred, essentially, if that ends up being the rule applied here, then the House would basically be allowed to intervene at the injunction stage, because it's been frozen at the injunction stage. It hasn't moved
Well,
forward towards-
there was a temporary injunction issued,
Right.
and so it was stayed after that. We filed a motion for summary judgment, but that has not been ruled upon, and so the House could come in at that point and make arguments. But, Your Honors, we would propose that there's, assuming that this court's decision stands, that there's nothing more to be done.
Well, I
in
mean,
the
the
trial court.
House doesn't have a very strong interest in saying we have the right to defend the injunction, because they weren't there to defend the injunction. They should have been there to defend the injunction. They came in after the injunction.
Correct.
So, but they do have perhaps an argument on the merits, the ultimate. You agreed?
Well, Your
You
Honors.
agree with the first part. They
My-
weren't there to
my-
defend
my-
the injunction, so.
My position would be that the trial court has already reached the merits, and under this court's Silver Rose decision, that once the trial court has reached the merits after a full evidentiary hearing, that is binding on this case.
I don't understand. If the parties agreed to it, I've had cases where we have an injunction hearing and the judge rules, and parties say, well, we see the handwriting on the wall, we're going to lose this case, so let's just stipulate to a final judgment.
Well,
and then appeal. But that's not what happened here, is it?
I do encourage you to read the Silver Rose
Well, I'm
case.
looking at the record here. I don't see
Yeah.
where the trial judge converted the temporary injunction into a final judgment.
Right. But, I mean.
Right? He hasn't done that, has he?
Well, he has not issued a final order, but we would purport that what you're doing here is you're saying that after we've already had all of the evidence, after we've already gone through all of this, we filed a motion for summary judgment, that now you're going to come in and reopen everything and let it go anew?
Well, they take intervention as the case stands. The
Right.
trial judge doesn't have to open up anything.
And they also are not allowed to interject new issues. And the issue that they're trying to say on the separation of powers is not been made an issue in this
But
case.
wasn't it injected by the trial court? Because as I read the trial court's order here on the intervention, the legislature has absolutely no authority to either intrude on or attempt to marginalize the responsibilities of the executive branch. So it's pitting the legislature against the executive branch, saying, legislature, you can't do it, but the executive branch may be able to do it.
Well, I think what he's saying is that, as the Florida Supreme Court says, the amendment gives the department the right to come in and the obligation to come in and issue reasonable regulations, and that the legislature can enact laws, because the amendment itself says the legislature can enact laws. Those laws just can't be inconsistent with the amendment, and what the legislature did is inconsistent with the amendment.
So the
Or
remedy, go ahead, sorry, you
Go
go
ahead.
ahead.
Or inconsistent with what the department does? I mean, usually we're talking about regulatory authority in the other direction, that the legislature sets the parameters for the regulations.
Right.
Here, what I read the trial court to be saying is that the legislature can only do what the department says that they can.
Well, what happened in this case was the department was proceeding to do the reasonable regulations and was proceeding forward, and the legislature came in and stopped them and said, if you keep going with that, we're going to freeze your funding. And so the legislature interjected itself and wouldn't let the department do its job.
So there is an issue between the department and the legislature.
Well,
They're pitted here.
there may
For
be,
authority.
but it's not for this case for that to be decided, because here, the amendment says the department is supposed to issue reasonable regulations, and the department is doing that, and that's what the court's injunction says
But it
to
also
do.
allows the legislature to legislate.
But by finding that the statute is, by the trial court's finding that the statute is unconstitutional, all that the legislature has to do is meet in special session and come up with laws that are constitutional.
Not so easy. So the House, that was going to be my question, which you sort of answered, but so the remedy for the House is to try and convince the governor or the Senate president to convene an immediate special session, which I don't think it's wild speculation to assume that would have to occur. If this entire regulatory scheme, at least the definition of medical marijuana treatment centers, is declared invalid, to have a special session and attempt to essentially circumvent the trial court's ruling or come up with what you think is constitutional legislation, that's their remedy. They're not to be allowed to intervene in the case and defend their policymaking prerogatives that are granted to them. Remember, under the Constitution, they have all policymaking power. The organic document is a limitation. It's not a grant. That branch has all policymaking power in the state of Florida,
Unless,
limited by the organic law.
Right.
It's not a grant. It's not a grant of power. It's a limitation of power. So that medical marijuana amendment is a limitation of the House's plenary policymaking power. And yet they're not to be allowed to intervene in the case where a circuit judge has declared that their policymaking powers were improperly applied.
Your Honors.
That's your position.
It's a plain, I recognize that this is a very unusual situation.
To say
But there
the least.
doesn't have to be any legislation to be implementing this amendment, because the amendment states that the department is supposed to issue reasonable regulations. If
It's
the
not self-executing.
Yes, I would disagree, Your Honor.
How is it self-executing when it has to tell the department to enact reasonable regulation and in the same time tells the legislature, and you can also adopt or enact statutes consistent with this amendment?
You know, what
That's obviously not self-executing.
The meaning of you can enact regulations does not mean that you have to enact
So is
regulations.
it your position then that neither the department nor the legislature need do anything to regulate medical marijuana?
No, Your Honor, that's totally not my position.
Right, so the amendment's not self-executing.
Your Honor, the amendment is self-executing to the extent, well, it does tell the department to implement regulations, so it would not be self-executing from that standpoint, but it doesn't require that the legislature implement any regulations or any policy, because the policy, as you state, the Constitution has put a limitation on the legislature's ability to enact laws in this regard, and it can enact laws. They just can't be inconsistent. What the legislature did was inconsistent. It came in too late, and there is no need for any legislation to proceed in order to implement the amendment. Your Honors, I see that my time is almost up.
I want to give you 2 more minutes, and then we'll give the appellant 2 more minutes.
Okay, well, Your Honors, I think that the Florida Supreme Court has spoken. I think that the House has waited too late to come into this proceeding, that we've already had the evidentiary hearing. It is trying to inject issues, elevate itself to the state of a party. A intervener is not allowed to raise new issues, and we would ask that this court affirm the order denying the House's motion to intervene.
Thank you. You didn't use hardly any of your extra 2 minutes.
I didn't know.
If I could ask you keep your thought. If I could ask you a quick question. If this other case, the injunction case, continues forward through this court and probably to the Florida Supreme Court, there'll be a stay in place, correct? Most likely, like there is now, right?
Presumably,
Okay,
yes.
so if we rule for you in this case, saying you should have been allowed to intervene, where does that get you? Because it seems like the ultimate issues will be are up on appeal, and the action in the trial court here may not come about until there's actually a final judgment in the trial court.
Sure. Judge Mayclar, if you're asking, well, what happens if the temporary injunction decision is taken up to the Florida Supreme Court?
Right, it's here for now, and if it goes to the Florida Supreme Court, I'm just saying the trajectory of that case is probably on its way to the Florida Supreme Court.
Sure.
Where does that get you if we rule for you in this case? In other words, the bus has already left the station on the injunction. You weren't there, it's up on appeal. But if we rule that you should have been allowed to intervene, that was really only for purposes of a final judgment, but that case is stayed below. So it seems like if you win this case today and you get to intervene, nothing's going to happen. There's nothing in the case below happening.
Well, hopefully eventually there will be something that happens in the trial court, and the court should take the record as we have it now and, looking at was there a procedural error, was there an error that was committed at the time we moved to intervene. Hopefully the temporary injunction decision, I quite frankly don't think that one is ripe or ready to go to the Florida Supreme Court. Maybe if there's a rehearing here, we don't know. But we're coming to the court asking to intervene. Hopefully, there's more proceedings that occur in the trial court, and which then gets me
I get
to
it.
what would we do?
I get what you're saying, yeah.
What would we do on intervention if it isn't already done, even if it's back in the trial court? And the answer is no, it's not done. And what I want to do is answer not everyone, Florigrown in the trial court and on appeal and the oral argument last month, Florigrown's been asking these rhetorical questions of, and in fact, Florigrown admitted at the oral argument last month that, well, maybe caps would be constitutional. They're not necessarily saying they're automatically unconstitutional, but there's no rational basis, there's no reason that's been shown as to why these caps are in place. And there was an exchange between counsel and Judge Wolf at the time about, well, was there already a trial on this? Is this final? And the question was asked, or was pointed out by Florigrown 59 minutes into the argument, that the question was asked, what is at the evidentiary hearing, what was the rational basis? Why are these caps in place? And Florigrown pointed out, well, all the Department of Health could argue, and this is in the context of, is there a substantial likelihood of success, and was that shown? Did Department of Health meet Florigrown's evidence to the contrary? And all the Department of Health supposedly testified, and I don't have access to that part of the record yet, or I haven't reviewed it, that the caps were in place because the legislature stuck them there. And what we ask, what we would do on, if we're allowed to intervene and back in the trial court, is to answer that question. The trial court still may not agree with us. And Judge Makar, I know you've expressed your view of the law so far. We'd like the opportunity to present evidence, perhaps change the minds of the trial judge, and present evidence.
Let me say this. In the absence of the constitutional amendment, if the legislature had passed this piece of legislation, the statute, it seems like there's pretty reasonable regulations or statute they've put in place, right?
Yes.
The only question in that case was, is there a conflict with the Constitution? Okay, so if there weren't a medical marijuana amendment, the legislature has pretty broad powers to legalize it if they chose to do so and to put limitations on it.
And but the issue's been raised. Florigrown has framed the issue by saying that, well, it's not necessarily that the caps automatically, or vertical integration is necessarily unconstitutional. Well, it's a different question about the vertical integration. But at a minimum, the House wants to intervene, to put in evidence, to answer the questions that everyone's been asking, but won't let the legislature come in to answer. And is, why was this law passed?
Well, I did give you 2 extra minutes. I'm going to ask you to conclude.
Okay. Your Honor, it's Glisson controls here. The House has a direct and immediate interest in the outcome of the case below. And for these reasons and for the reasons I stated before, the House asks that the court reverse the order denying intervention and allow the House to intervene and participate in trial court below, going to final hearing, not to rehash what has already occurred, just to go to final hearing. Thank you.
Thank you both for your arguments.
All rise.